As discussed previously, there's two big categories for employment-based petitions, which include non-immigrant purposes and immigrant purposes. And both categories will include completely different steps and completely different documentation and proof that needs to be obtained. We will start with non-immigrant purposes employment-based petitions. So what does it mean? That means you would like to enter United States. Maybe you were a student here already studying on F1 visa, and you would like to experience work environment in the United States, or you have a specialized degree, so now you would like to relocate and work for some temporary time. So that usually includes a period of time from 6 months to 3 years. Now, to start the process, one needs to, first of all, obtain employer. So I always say the employment-based petitions includes three parties, which would be legal representative, client, or the employee and employer themselves. So you do need to have an employer who is willing to petition for you. In most of the times, depending on the petition, employer will have to obtain a labor condition certification. So your employer will have to work with two major agencies. One is Department of Labor of United States to get approval there, and then USCIS itself to get your employment petition visa. For immigrant-based employment petitions, the process is very different than for non-immigrant-based petitions. So what is immigrant-based employment petition means? That means you would like to relocate to United States for permanent basis, and you would like to get your green card through your employer and eventually become a citizen. Now, as you can imagine, the process is lengthy. Now, what employer needs to show to United States, to both Department of Labor and USCIS, that there is no one else in the United States that will qualify for the position that they have available, and the employer tried in good faith seeking for candidates for this position for a period of time of at least 30 days or more and wasn't able to find any good candidates, right? So we need to make sure that's a first step to ensure that there is no one else that would qualify in the United States. And the second step is to prove that the employment of this employee will not harm in any way existing United States citizen candidates that might be interested in this job. So there's a lot of steps that are required. So it's going to be very important to work with someone who understands all the requirements and who does have an experience working with employment immigration-based petitions. The steps will require working with United States Department of Labor, which will be requiring PERM certification. So it's a labor condition certification, and also USCIS approval. Now, very important point to understand that once United States Department of Labor approves your petition, you still have to prove to USCIS, to Immigration Services, that there is sufficient employment-based petition, and you still need to prove that this employer will be able to pay for the employee, and there's no one else that will qualify for this position. So what I'm trying to say here, just because if you got approval from Department of Labor, doesn't mean that USCIS now will approve your petition. You still have this challenge, right, to show to United States that the employer will be able to pay for this employee and that there's sufficient requirements that are all satisfied.